Hey, how are you guys doing? I'm Daniel Flanzig. I'm a partner with the law firm of Flanzig and Flanzig, also known as New York Bike Lawyers. And we are continuing with our video series today. We're going to talk about another case that just came down on March 26, 2020. A very, very important issue for anybody that is a bicycle courier, a bicycle messenger, or working for any of the companies out there. It's also very important if you are involved in a crash with any rideshare vehicles or any app-based companies. It is a case that came down from the Court of Appeals, the highest court in New York State, in the matter of Vega. I'll give you the site if you're interested. It's 2020 New York Slip Op 02094, decided on March 26, 2020. So what's Vega about and why is it important? In New York, we have normally two different types of employees. We have a regular W-2 employee on the books, and we have independent contractors. And in the new age of app-based employers, we kind of have this new thing where people, are they employers, are they not employers? And it creates issues in two different realms. It creates issues for the employee, whether or not you're entitled to benefits, and it creates issues for somebody that is injured by one of these people, because in New York State, an employer is responsible for the acts of its employee. So the issue for a bike messenger or a courier person is, are you entitled to unemployment insurance? Are you entitled to workers' comp? All the benefits that would accrue to an employee. And in my world, what I'm usually looking at, can I hold Uber, Lyft, or any other of these new rideshare companies responsible for a crash if one of their drivers causes an injury? And according to Vega, the answer is yes, in the realm that Vega gives us. So let's talk about what Vega is and why it's important. Vega was working for Postmates, a courier system where employees for Postmates are required to make contributions to the unemployment insurance fund. And Postmates, as some of you may know, is a delivery business that uses a website and smartphone app to dispatch couriers to pick up and deliver goods from local restaurants and stores in major cities throughout the United States. The issue becomes control, and here the courier decides when he or she is going to log on to the app and work. However, the decision whether or not to give that employee work is ultimately left up to Postmates. So they complete an application, Postmates decides to hire the courier, and they go to work. Postmates then would pay the courier 80% of the delivery fees charged to the customers, and they would keep the difference. So Mr. Vega is working for Postmates in 2015. He gets fired. He applies for unemployment insurance, and they get denied. I'm not going to give you the whole scenario, how it worked its way up to the Court of Appeals, but it went through multiple levels, including the unemployment ALJ, the appellate division, and then ultimately up to the Court of Appeals. And they determined that Mr. Vega was an employee. And here's what's the real important part. As relevant here, under the employment law, employment is broadly defined as any service under contract of employment for hire, express or implied, written or oral. Traditionally, the board considers a number of factors in determining whether a worker is an employee or an independent contractor, examining all aspects of the arrangement. But the touchstone of the analysis is whether the employer exercised control over the results produced by the worker or the means used to achieve that results. Here, there's substantial evidence in the record to support the board's determination that Postmates exercise control over its courier sufficient to render them employees rather than independent contractors operating their own business. The company operated through Postmates the company is operated through Postmates digital platform, accessed via smartphone app, which connects customers to Postmates couriers, without whom the company could not operate. While couriers decide when to log into the Postmates app and accept delivery jobs, the company controls the assignments of deliveries by determining which couriers have access to possible delivery jobs. So using that analysis, the court determined that Mr. Vega is an employee and entitled to benefits. Now quickly turning to the issues that come up for me quite often. and we've been successful in litigating, is if I have a client who is struck by a Lyft, Uber, or any other rideshare courier out there, I'm going to name the driver of that vehicle, its owner, which is usually the driver. Mostly Uber drivers own their own cars. And I have named Lyft and Uber in these lawsuits. Lyft and Uber traditionally takes the position that these people are independent contractors. They call them partners, and they are not employees of Lyft or Uber. That has been their position. This case says, under these scenarios, these app-based companies, where although the driver chooses when or she is going to work, once they log on, that app-based company controls who is going to be driving, when they're going to be driving, who they're going to be picking up, and how they're going to be collecting the fees and for how much. So under this case of Vega, which we're just talking about employment for the moment in Vega, that's the most it spoke to, but it's very easy to make the analysis that Uber drivers, Lyft drivers are also going to be considered employees for the purpose of the employment law and for the purpose of holding them responsible under what we call vicarious liability in New York State for the acts of your employee. So an important case, important thing to know in the world of bike law and litigation. And for now, thanks for watching. Stay safe.